Good morning, Chris Palazzolo for Mr. Caldwell. Okay, absolutely.
Do you need us to move up to where there's a microphone up here? If it would be better. Okay.
I was anticipating people speaking at the podium, for better or worse. I don't know if that works for everybody, but it sure, I think for both the court reporter's sake and for, I know this is being streamed as well, so that's why I thought it might be, provide more clarity. Madam Court Reporter, does that work for you to be able to get everything? Okay. think we'll just do that.
Okay.
Yes.
All right, the time is 10:07 a.m. Eastern Standard Time, and we are now on the record.
Good morning. I'd like to call this challenge hearing to order. My name is Vicki Acker, City Clerk for the City of Douglasville and Election Superintendent for City Elections. For today's proceedings, our legal staff, both internal and outside counsel, will guide us through this hearing process. At this time, I'll turn it over to them to proceed.
Good morning. Let me start again. Good morning and welcome to this hearing. This hearing will be recorded. Right now, it is 10:08 a.m. on September 15th, 2025. My name is Ted Meeker. I've been retained by the City of Douglasville to assist and provide legal counsel to Vicki Acker, the City Clerk for the City of Douglasville, and also the Election Superintendent. The Office of Election Superintendent received information concerning issues with Mr. Caldwell's qualifications to run for council member seat, Ward 3, Post 1. The basis for that challenge pertains to Mr. Caldwell's residency and was set forth in the letter from the Election Superintendent to Mr. Caldwell dated August 22nd, 2025. A timely request for hearing was submitted by Mr. Caldwell. The purpose of this hearing today is to provide Mr. Caldwell the opportunity to explain his residency situation and to provide support for the explanations. This is not a court proceeding, so evidentiary standards and court rules do not apply. I will add that the testimony is limited to issues to Mr. Caldwell's residency and that extraneous matters will not be heard or considered. This is also not a hearing in which we would invite citizens for comments. During the hearing, please do not applaud or make remarks from the audience. Mr. Caldwell, you'll be given 20 minutes to present your case. There is some flexibility that we can provide you in that regard. Both the election superintendent and myself may have some questions along the way. Obviously, that time will not count against any time that you're allotted. If something does come up where we get into some back and forth, we'll make sure that we add that time back to the total time you have. Do you have any questions, or do you or your counsel have any questions for us at this time?
Well, I have a concern and an objection, actually. I never received notice of this. I'm the one who sent Ms. Akers and the other city officials notice of our challenge. I still haven't received anything. I found out about this, my client, only a few days ago. So I'm objecting to moving forward. It's a 10-day notice. I didn't get notice. Therefore, I ask we be reset.
We are going to go ahead and proceed this morning,
Okay.
but it's noted for the record. I think the best way to do this is when somebody is coming up to provide factual information, they will be sworn in by the court reporter as a part of that process. If you would, you can go ahead and proceed.
Considering the ruling from the chair, we asked for a 10-minute continuance to just,
Yeah.
we're prepared. I thought that it would be moved, but if we could just have 10 minutes?
You mean a 10-minute recess as opposed to a
Yes.
continuance? Absolutely.
Thank you.
We'll go off the record for 10 minutes.
Great, this time is 10:11 a.m. We are off the record.
Are we ready to proceed?
Yes.
Okay. Hold on one second.
And just for the,
10:21 a.m., you're back on the record.
yes. Chris Palazzola for Demetrion Caldwell. And just for the record, we're going forward under objection based on the notice requirement.
Mr. Palazzola, before you go on with that, I remember receiving an email from you Friday night. It's sometime late Friday night, like 11:39, I think it was received.
And I apologize for that. I sent it like at 11 a.m. I saw that it got bounced back at like 11 p.m.
No, listen, my emails and phones, like probably you, they go off at all the time, so don't worry about sending something late. But I just want to make sure that we made reference to that during the course of this hearing, because I know one of the issues you're raising is one of notice. So I just want to make sure that at least by Friday at some point, you are aware of this hearing going forward on Monday.
Absolutely,
Okay.
absolutely. But I believe the requirement is 10 days. But it's fine.
And which provision of Georgia law are you citing for that?
I'm sorry?
Which provision of Georgia law are you citing for that, the 10-day notice?
I can get you the statute later. I just looked when I was driving, and I saw that I believe it's 10 days.
Okay, if we can circle back on that while we're on the record at some point, I'll give you a chance to look into that later, but I'll let you go ahead and
Okay.
proceed for now. Thank you.
If I hate to do it, if you give me 2 minutes, I can step out and probably get it.
Why don't you go ahead and proceed, we can circle back.
Absolutely. Good morning, my name is Chris Palazzola, and I'm here on behalf of Demetrion Caldwell and his candidacy that was wrongfully disqualified in violation of both the city charter and Georgia election law. By the city's own admission in their disqualification letter, the election superintendent acknowledged that Mr. Caldwell has been a resident of the city of Douglasville for at least 1 year, satisfying the requirement for residency. End of story, really. Despite that, the superintendent acted outside of the authority of the charter, which is section 2.1. I ask that you please look at. It's quite different than what is cited in the letter from the city, and denied Mr. Caldwell equal treatment under OCGA section 21-2-132, and stripped him of procedural due process guaranteed under OCGA 21-2-5. For these reasons, Mr. Caldwell's disqualification is unlawful and must be overturned so that his name is restored on the ballot. The section 2-11 or 2-11 of the city charter reads in pertinent part, no person shall be eligible to serve as mayor or council member unless that person shall be at least 21 years of age, and here's the important part, and shall have been a resident of the city for 12 months prior to the date of the election of mayor or city council. And clearly, the next paragraph, candidates seeking election as council member from a district must reside within such district from which they seek election as of the date upon which they qualify to run for office. I want to read that last part again. As of the date upon which they qualify to run for office. It's important to note. Additionally, my client was disqualified without procedural due process in that Georgia law provides clear standards for procedures for a candidate and their qualifications challenges. OCGA 21-2-5 establishes that questions concerning a candidate's qualifications must be determined by the appropriate election superintendent after a proper hearing. Here, he was disqualified well before a hearing, almost a cursory disqualification. 2, OCGA 21-2-5 little c requires that the candidate be given notice of the grounds for the challenge and an opportunity to be heard consistent with principles of procedural due process. And finally, OCGA section 21-2-132 little e prohibits arbitrary or selective enforcement of qualification standards during the candidate qualifying process. Mr. Caldwell was not, was asked by the election superintendent to provide the following to validate his residency, that was not required of anyone else seeking to be a candidate for a city council. He was asked to provide his driver's license, rental lease, check stubs, in addition to a signed affidavit. The other candidates or potential candidates were just asked for an affidavit. And it clearly violating equal protection. This documentation is not required to qualify. And as just stated, the other 5 candidates who were qualified, they only had to submit an affidavit, which is the only document required to qualify. Additionally, it appears from our brief investigation that the election superintendent for the city of Douglasville did a independent investigation either prior to his qualifying or did a rush after he, or no, he hasn't qualified, but prior to, either before he submitted his affidavit to qualify or did a rush one in the day thereafter. But the election superintendent was outside the scope of authority granted under Charter 2-1-1, and contrary to OCGA 21-2-5, when they conducted an independent investigation on my client. And that independent investigation, requiring him to submit additional documentation and then looking up where he resides, looking up who owns that property, which it was a corporation, then having to, I imagine, go to the Secretary of State's website, looking that up to see who owns or who is a member of that corporation or the owner of the LLC, determining it's the city judge here in Douglasville, how convenient, and then going to Judge Rollins and further investigation and going out into the field and talking to Judge Rollins, finding out what he has to say, basically interviewing the judge and getting his statement, which I think is unconscionable. And it smacks of additional prejudice in that he works for the mayor. We're claiming the mayor is going after my client because he ran against her for mayor, and she controls their employment, provides an affidavit on her support, or supporting her.
I'm sorry to interrupt you. Which portion of the city charter are you claiming that the judge is appointed solely by the mayor as opposed to by the council?
Well, he's appointed by the mayor, and then the council has to approve it or not.
Okay. I'll have to look that up.
Right? And the mayor is the only one who can fire him. Well, he could be impeached, I imagine, by the city council, but pretty important to have the mayor's backing.
Okay.
This, by the city's own admissions in their disqualification letter, my client meets the standards to be on the ballot. He has been a resident of Douglasville for at least 1 year, and that alone meets the residency requirement. He's been a resident really his whole life, or at least since he's been like 7 years old. Yet, despite my client's longtime residency in this county and being an elected official in the past, he has been denied in violation, most importantly, I would say, of the city charter section 2.11, which is being selectively enforced in violation of OCGA 21-2-132. And again, denying my client procedural due process guaranteed under OCGA 21-2-132 and 21-2-5, as well as the United States and Georgia Constitution's equal protection and due process clauses. And so Thank you. That was my opening. Should we go ahead with my witness?
Please do.
Okay. Should you just stay there? Should-
I think he's welcome to come on up to the podium. That way the microphone can pick up everything he says.
All right. Please state your name.
Well, before we go on with that, I'm gonna swear you in. Is it Mr. Rollins, Keith?
No, ma'am.
Okay.
Devitrion Caldwell.
Okay, I'm sorry, I have a different one. So what was your name? Sorry.
Devitrion Caldwell.
Okay, all right, can you please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Counsel, you may proceed.
Thank you. Please state your name.
Devitrion Caldwell,
What is your address?
7117 Crystal Creek Place.
Okay. Do you have another address?
Yes.
Okay. What is that address?
8651 Bowden Street, Douglasville, Georgia, 30134.
Okay. And going back, the first address, is that what district, city council district is that in?
Ward 3, Post 1.
Okay. Why do you have two addresses?
Well, I didn't think that we would have to do this, but I am dating. And so, as many of you know, I am a self-sufficient, or would assume, I'm a self-sufficient young man. And so dating presents different challenges. And so I like to be able to be self-sufficient and take care of myself. So I do reside with my partner at another address, but as it states that there are rocky relationships that take place, and I still like to be able to just feel comfortable making sure that if something does not work out, then there is stability at another address.
And do you have well, in the disqualification letter, you have a lease with Judge Rollins or the corporation for the Bowden address, is that correct?
Yes,
And you have a lease for the Crystal Creek address?
yes.
Okay, and now, that has been submitted to the board. I can submit that a copy?
If you would, for the record, that would be great.
Okay. Do you have one?
Is that a copy that we could put into the record, or, okay, I just want to make sure we weren't taking his original.
Well, no,
copy.
it is actually the original.
Okay, so you'll need
because
us
the city
to-
had the copy from when I qualified.
Okay, I haven't seen anything, so that's why
Okay,
I was asking. Maybe at the break, we can get a copy made for the record and return this one to you.
okay,
Absolutely.
sure.
All right, I'd like to show you the lease agreement for the address of 7117 Crystal Creek Place, Douglasville. Do you recognize that?
Yes,
Is that, well, not a copy, is that the actual lease?
yes,
Okay, and we submit that as, I guess, exhibit number 1.
That's fine?
What is your take on the requirements under section 2-11 to be on city council?
I mean, it's my take that I am duly qualified under the code section. Back in March, I reached out to the election superintendent just to be clear on what the requirements were to run for city council. And in that email that I received in March, it stated that you have to be a resident of the city for at least 12 months prior to, and it also cited the code section of the City of Douglasville Charter 211.
So, so the city has known you've been interested in running for this since at least March, is that correct?
Yes, I think it's been public knowledge that there's my interest to run for this seat, as Douglasville is small. But of course, there's a lot of chatter about everything usually. So everyone, or I would like to say most people, have been made aware of this potential candidacy.
Turning your attention to the mayor, your relationship with the mayor has changed over time, has it not?
Yes.
Can you
Mr.
tell-
Palazzolo, I meant what I said earlier. I mean, I understand and you've made your point about your theory, and I can read the appeal letter. I'll be honest with you. In speaking with Ms. Acker, I will tell you that this is a box checking thing. They either qualify based on residency and other qualifications under Georgia law, or they don't. And that's really where my focus is going to be in providing legal guidance to Ms. Acker today.
My bad, I didn't, I probably need to go to the doctor. I
That's fine. That's fine. Now, you've made your point about why you think this has happened. I've heard that. That's already a part of the record. Again, I don't view that as being germane to why we're here today.
Okay, that's fine. Can I have a second with?
Absolutely.
Off the record,
Do I tell you what, I don't think we need to go off the record. I think we can just pause for a moment.
Now, did you have to file an open records request?
Yes.
Okay, and what did you learn from that open records request?
What I learned from the open records request is that upon me qualifying, when I went to qualify, I signed the affidavit, as I was told was the only thing required for me to qualify for this seat. And so I submitted the affidavit on the Tuesday and then signed the affidavit or tried to qualify on Tuesday. I was told that there was some more information that was needed from me to be able to fully qualify. Also understanding that I've served in public office before, I've qualified many times, so I'm pretty familiar with the process of how to qualify. And so I qualified, I was told, that was on Tuesday, I was told on Tuesday, that I needed to provide additional documentation. On Wednesday morning at 10 o'clock a.m., based on the additional documentation that I was asked to provide, although I knew it was not necessary to qualify, I came on Wednesday morning at 10 a.m., provided the additional documentation that was what I found from the open records request above that was requested of any other candidate that qualified. So every other candidate that qualified only submitted an affidavit. Whereas you mentioned, I submitted a rental lease, driver's license, check stubs, et cetera, to the city's request to further prove my residency.
And what day were you asked to provide the additional information?
That was on the 19th, Tuesday, August 19th.
And what day did they inform you that you'd been disqualified?
So on Wednesday, August 20th at 10 a.m. or closely after, once I presented the additional documentation, I was told that I was qualified. I was then told by the city clerk, and who I am very fond of, as I don't have any ill will towards anyone, but I was, of course, told that I thought it was oddly stated that it was stated that I want you to know that I am not picking on you, but the questions that I am asking or the things that I ask you is because I've been asked above me. And so I didn't know what that meant, but I just said, hey, listen, things will be what it's gonna be. And then it was also stated that now if you do not qualify, then you do not get your money back. I also thought that that was a strange statement for someone who had qualified before, but also as a representative of the city. And so then I was told that I was qualified. And I was then told that there was an opportunity that my candidacy could be challenged. Of course, I thought that was strange as well, given that I had seen, around Douglas County challenges before and how they were brought. But to me, everything that was done prior to me qualifying, to me, I thought was very strange. So needless to say, I was told that I was qualified, and I then, of course, made the notice public that I had qualified. I then received notification, which was a cryptic email I didn't understand on Thursday, stating that I did not meet qualification. And then I received 2 emails following saying that the email had to be recalled. I then followed up with Ms. Vicky asking, hey, I received 2 emails stating that the email had been called. She stated that she needed to correct the city council post thing. And then I received post name or number, one of the 2. And then I received received another email stating that I did not, on Thursday, stating that I did not meet qualifications and that a formal letter would be sent to me on Friday morning. So then I received the email from Friday morning stating the reasons for my disqualification for city council.
Okay. And, now earlier you heard me reference, Judge Rollins, who ultimately I guess is one of your landlords. In their investigation, did they call your other landlord?
No, they did not.
So they looked at the Bowden address, which isn't in District 3. Did they try to confirm that you live in District 3 by going to the Crystal Creek address?
No.
And so, you submitted your affidavit on Tuesday, and it was Thursday that you were informed that you were, off ballot? Or not on ballot?
So I officially submitted it. I tried to submit it on Tuesday, but I was told to bring it back with my receipt on Wednesday with the additional information that was requested. And so I submitted it to Wednesday, before 11 a.m. I had submitted all the information. And then it was Thursday evening at the close of qualifying that I received notification that I did not meet qualification. I will also add that on Wednesday, I was told that the candidates who qualified, qualifying had to be complete by 5:00 p.m. and that it had to be to the newspaper so that they could post the names of the candidates who who had qualified for city council. But of course, I did not myself, nor did the newspaper, get that notice by 5:00 p.m. because it wasn't until Thursday evening that I was made aware that I did not meet qualifications based on what the city stated as their determination in the disqualification letter.
Now I would ask you to open up your, the folder that it says open record request, please. What did you request from the city?
What I requested from the city was open records request showing all documentation of every candidate who attempted to qualify and who qualified for city council.
And what did you learn?
What I learned is that based on the open records request that was fulfilled, is that every candidate who qualified submitted an affidavit that was notarized and that was accepted by the city as proof of residency and qualification.
How many other people are qualified?
I think it's a total of 5. Let's see, 1, 2,
And
3,
how
4,
many of them
5.
had to submit their driver's license?
Based on the open records request, no one else.
How many of them had to submit their leases?
Based on the open records request, no one.
How many of them had to submit any additional proof of residency other than the affidavit?
Based on the open records request and that what was submitted to me, no one else provided any additional information other than an affidavit.
No further questions?
I have a couple questions, and then, of course, Ms. Palazzo, I'll let you ask questions, any follow-up to my questions. Understand your testimony talked about how you technically have 2 residences.
Yes.
Okay. I'm sorry, I didn't write them all down. The one that you're claiming as your residence is the 7117 Crystal Creek Place, correct?
Yes.
Okay. Who owns that property?
Desmond Waller.
Okay. And how long have you had that as your address?
So based on what was submitted, it was 1 year and 6 months.
Okay. And then the other residence that you referenced, and I'm sorry, I didn't write down both addresses.
No, that's fine.
But how long have you listed that, or how long have you had a lease? Do you have a lease at that other address?
I do.
Okay, so your name's on 2 separate leases?
Yes.
Okay. And that's the one, I guess I'm gonna hear more about at some point, that Judge Rollins has a company that owns that other address?
I presume.
Okay. Whoever,
Yes, corporation.
okay. Are you paying the rent at both places?
Yes.
Okay. Did you bring any proof of the rent payments for both?
No.
Okay. Your driver's license, which address does your driver's license show?
Crystal Creek Place,
Okay. And what is the date that that license was issued?
let's see, the date was August 19th.
Okay. Of this year?
Yes.
Okay. And how about your voter registration?
I'm not sure. It's my understanding when I went to DDS that it was retroactive. But as it relates now, my voter registration does match my license.
Okay. How about on the date of qualifying, where did it show as your registration address for voting?
It should have showed the Crystal Creek Place. As I mentioned, the Department of Driver Services said that it was retroactive. So I'm unsure if it was retroactive when it was pulled, but that's what the pertinent information I was given based on DDS.
Okay. Those are the questions I have. Let me ask Ms. Acker. Okay, no other questions at this time. And again, if you want a minute to think about if you have any follow-ups, you're welcome to take that.
Thank you. That, we rest.
Okay. Does anybody from the city have any information they want to provide? Can we do this for a second? I would like to take a look at that lease that we've identified as Exhibit 1. Could we go off the record? Is there somewhere I can get a copy of that made? And Ms. Prezzo, with your permission and your client's permission, I'm going to make 2 copies, one for obviously our file and one for the court reporter to take as an exhibit. Okay. Let's go off the record for a minute.
Time 10:48 a.m., we are off the record.
better or worse, I did staple it, so. Have it. We're gonna go back on the record.
Time is 10:55 a.m. We are back on the record.
Just for the record, I made a copy of Exhibit 1, furnished it to Mr. Caldwell's counsel, and also an original to the court reporter. I had one more follow-up question, Mr. Caldwell, if I could. Had you ever qualified to run for office before?
Yes,
Here, for Douglasville, Douglas County, or another office?
both.
Oh.
I was elected on the Board of Education for Douglas County, and then in 2023, I qualified to run for mayor for the city of Douglasville.
Okay, which address did you use as your residence for those other elections?
For both prior elections was the Bowden Street.
Okay. Thank you. Ms. Palzo, do you have any follow-ups you wanted to ask to my questions?
I'm sorry?
Did you have any follow-ups you wanted to ask to my questions?
Yeah, briefly. Mr. Caldwell.
Yes.
Can you, have you looked at OCTA 21-2-1?
Probably, yes.
Did anyone challenge your candidacy?
No. Not to my knowledge, no citizen challenged my candidacy.
And have the procedures for disqualifying a candidate been followed?
No, sir.
How have they not?
Based on my understanding, and of course, with all the legal experts, you would be able to give a better definition. But it's my understanding that a challenge could be presented. However, there's a process for how it needs to take place. And so it's my understanding, based on what I read, that if there was a challenge to come forth, the election superintendent can challenge it. However, I'm supposed to remain qualified until a challenge is brought. After that challenge is brought, I'm to be notified within 2 weeks that there's a challenge and be scheduled for a hearing. As it stands, none of that happened. The only reason that we're here for a hearing is because I challenged it. The only reason that, as far as the disqualification, everything happened prior to a hearing, which goes against what you just referred to in the OCGA code.
Now, in the news, we hear a whole lot of hoopla about this stuff called due process. Do you think you were given due process?
I was absolutely not given due process.
And what code section is that? Is that 21-2-6?
I'm gonna say yes. Okay.
Thank you.
Okay. Anything else?
Nothing further.
Okay. Is somebody from the city gonna present something?
Yes, before I do, I would like to provide a witness if that is allowed.
Of course.
I swear the testimony I'm about to give in this matter and opinion for this body to be true and correct to the best of my knowledge, so help me God.
Alrighty, council may proceed, I guess. I've never had a words like that, but I think that's fine. I think the parties are a little reversed in this case. My name is Miranda Jordan for the record. Can you state your name for the record?
B. Keith Rollins.
And do you have a landlord-tenant relationship with Mr. Demetrion Caldwell?
An LLC that I am the managing member does, yes.
What's the name of that LLC?
Sunsets Unlimited LLC.
And does Sunsets Unlimited LLC own the property located on Bowden Street that is the property subject of the discussion we previously had in this hearing?
Yes.
Has Mr. Caldwell indicated to you an intent to terminate his lease at any time?
No.
Is there a written lease in place between the parties?
Yes.
And does that written lease indicate that this is a month-to-month lease, or is this a long-term lease?
There is no expiration date. Each party to my leases have the ability to cancel and terminate the lease with a 30-day notice.
And do you have an extra copy of the lease?
I only brought the one. Went back and looked at the date on it of 2023. That was when Mr. Caldwell moved to the Bowden Street addresses, which is contrary to his testimony that he lived at Bowden Street when he qualified for school board.
Has he ever lived in any other property owned by you?
Yes.
Or owned by your LLC?
Yes, 6636 Woodrow Avenue, Douglasville, Georgia, 30134.
How much does he pay in rent each month?
$1,150.
And he has paid that rent ever since the beginning of this lease in 2023?
Yes. Well, not in that amount. It was a lesser amount when he began residency at Bowden Street in the amount of $975.
Do you require your tenants to have utilities placed in their names? Or do you require this tenant to have utilities placed in his name for this property?
As opposed to the LLC maintaining the utilities, yes. If he wants utilities, they'll have to be owned in his name.
That's all I have at this time, thank you. If Mr. Palazzolo would like to ask any questions.
Good morning, Your Honor. How are you?
Good morning.
Do you require that the utilities be in his name, with the renter's name, or just not in Sunset Unlimited?
I don't require it to be in any specific entity's name as long as it is not in the name of Sunsets Unlimited.
So as long as Sunset Unlimited isn't paying for the electric or anything else?
I don't care.
Exactly. Thank you. And when, do you know what date the city reached out to you to inquire about Mr. Caldwell's residence?
No,
Was it the mayor that reached out to you?
no.
Who reached out to you?
Ms. Jordan,
And what did she say?
wanted to know if he rented from me and I believe when. I don't recall the exact conversation.
Did she say how she found out that you were his landlord?
No,
Can you remember anything else about the conversation?
no,
Did they tell you why they were inquiring?
yes.
And what did they say?
That there had been a challenge filed to his residency to qualify for running for office.
Okay. And it's actually where you intend to live, is that correct, under the law? I know.
Restate?
Yeah. Have you ever talked to the mayor about Mr. Caldwell?
No,
Have you ever talked to anyone else with the city about Mr. Caldwell pertaining to this?
only to Ms. Jordan and possibly Mr. Dotson.
Can you tell me what, Mr. Dotson?
Yes, city attorney.
Oh, okay. As long as it's not attorney-client privilege, can you tell me what you spoke about? Yeah, I imagine she would object.
No, the only thing that was ever mentioned was that there was a challenge, and she asked if there were leases and rent records, and I do have those here.
Okay. Did she inform you she was looking into all the candidates?
No,
Thank you, Judge.
redirect? I'm sorry.
No, but just for the record, I wanted to state that any communications regarding this would not be subject to attorney-client privilege because they have no bearing on his duty as a city judge.
I didn't hear an objection, so.
And a point of clarification, I know you terminated the discussion of this. The mayor does not control the employment of a municipal court judge.
I actually looked up the charter, Judge Rollins. Yeah, and it's clear that it's the mayor and council. And the mayor, of course, under the charter only votes in the case of a tie.
Make
So,
the
yeah,
recommendation.
I looked it up because I was curious about that. I know that some charters are different. It's what Mr. Palazzolo said in terms of the mayor making an appointment and a council confirming, but this is a straight appointment under Douglasville Charter, 4.11 has it
And-
clear. But nonetheless,
And only subject to being removed for cause, not at the whim of the mayor
well,
or
the
council.
state law changed in that regard a couple
sir.
of years ago. I'm familiar with that with my other municipal work, so yeah, I get it. Okay.
I just have one brief additional question. Your Honor, do you know who filed this challenge to
No.
Mr. Caldwell?
No idea.
They didn't tell you?
No,
And you wouldn't have, that wouldn't be something that you would get?
No.
Thank you.
And Judge, do you mind if the city makes a copy of that to keep in the official file?
I brought these for you and will state that these are made from business records maintained in behalf of Sunsets Unlimited LLC.
If you would show them to Mr. Caldwell's counsel,
Yes.
and then assuming there isn't, then I think we'll label it as Exhibit 2.
Again, no objection.
Thank you.
It's
So is that
admitted.
Is that just the lease, or is there more?
There's a lease for 8651 Bowden Street, there's a lease for 6636 Woodrow Avenue, and there's a record of rent paid for Bowden Street. moved, it says.
I have no further questions for the judge.
No further business for this body, may I be
Let
excused?
me ask, do you have anything else you want to add? I have no other questions, but as far as I'm concerned.
Thank you.
You're done.
And the city would like to make a brief statement.
That's fine. I have one question, and I don't know if everybody wants to make statements or if you want me to ask the question. The voter registration, do we have any record of what address was shown on the date? I know that the license was, that you had the license issued, I heard, on August 19th. And I know that as of that date, the address would change to that address. But in terms of prior to that, what address was shown for your voter registration?
Prior to August 19th?
Yes.
So as stated, prior to August 19th, my license did show Bowden Street.
Okay. You had said you thought it was retro. I never heard what it showed before the date you got your license issued.
Yeah,
For
so the statement regarding retro was based on August 19th when when I went to DDS, and I was told by DDS that it should show in real time that my voter registration matches my license.
Okay. All right. Then sure.
And Mr. Milton Kidd is here. He is the Director of Elections at the county, and he would handle all voter registration matters for the county if there are any questions that you would like to ask him.
Well, kind of a follow-up to what I just asked. I'm just trying to clear that up.
Okay.
If he is willing to give us some information on that, that'd be great. But he needs to be sworn in.
Sir, can you please raise your right hand? You swear or affirm that the testimony given in today's case will be the truth, the whole truth, and nothing but the truth?
I do.
Great, thank you. Councilman,
Your question, I believe the Bowden Street address was the address that was reflected on the voter registration prior to the 19th. The way it works is when you go to driver's services and update your driver's license, on that day, the elections office gets a record of that change. So even if the elections office does not update it on that specific date, the date of issue is the date of voter registration. So if a license is issued on the 19th, that is the registration date as well. As far as a previous question that was addressed to, you are referenced county elections. The county election, to my knowledge, Mr. Caldwell has been a candidate for 2 different times with the school board. So I want to make sure that you all are using the correct information of which candidacy for the school board you were previously referencing when you stated the county.
Okay. Is there any information provided to the city ahead of time in terms of addresses of electors in the city that is, and if so, when is that given to them?
Prior to qualification, the city does get a list of voter registration information for individuals that are registered in that city. I will add the caveat that that list of voter registration information is pulled at a specific date and time. So individuals that are updating their registration, as is their right to do on a day-to-day basis, that information is not updated unless the city requests an update each day for that information.
Okay. Do you know when that was provided to the city for this election?
Typically I can't give you an exact date, but typically for an election of this sort, my office provides that within a 1 to 2 week time frame prior to the election.
Okay. Those are my questions.
What if, good morning, sir, how are you?
All right, and you,
My name is Rich Pelzo, I represent Demetri Nicola.
yes.
What are the requirements to be able to get on the ballot for city council?
For city council, as stated in the city charter, an individual must be a resident of the city for a 12-month period prior to the election. For the specific council districts, I do not believe that there is a residency requirement in the district prior to actually taking office. What the charter says is that an individual has to be in the district at qualifying.
That's correct. And so it's 12 months prior to the actual election, is that correct?
The 12-month period is for a city resident prior to the election, yes.
Okay. And would that be the same for a district?
A district, correct me if I'm wrong, the city charter has a caveat that says, what is it, 2-11, I believe, that an individual has to be in the district at qualifying, and you all can get the exact wording from the city charter.
It's gonna speak for itself, so yeah. Whatever it says.
And so if Mr. Caldwell's address was as of February of 24 in District 3, in your expert opinion, does that make him qualified to sit for the November 25 election?
The date that is reflected on the voter registration information on MVP is the correct date of voter registration. You all can refer to the date that is listed on my voter page, which is www.mvp.sos.ga.gov. I don't specifically know offhand the individual's registration date, but it is reflective on the state's website for voter registration. That is the date of registration. For the purpose of this hearing and for any administrative purposes, you all can refer to that date that is being displayed on the state's website as the date of registration.
Okay. And have you, how many of these types of hearings have you been to, challenging somebody's requirements to sit?
I've been an elections official the last 14 years or so, so I can't enumerate the specific number of voter challenges, but let's just say a lot.
A lot, okay. And now, is the candidate or potential candidate, are they supposed to get notice before they're disqualified?
A candidacy that is challenged, typically when a candidate's candidacy is challenged, they do receive notification of that challenge. And a hearing is set at that time.
Okay, so they're supposed to get notification that they're being challenged and then set up a hearing?
That's my interpretation of election code. Please refer to legal counsel as it relates to this is not a county matter.
So that's interesting, you bring up, notice that they've been challenged. Do you know who challenged Mr. Caldwell in this instance?
The county has no responsibility for qualifying city candidates. We simply administer the election on behalf of an intergovernmental agreement with the city. The city itself is responsible for qualifying all candidates and turning over that legal notification to the county. So this would not be a matter that the county would have been privy to.
Okay, and even though it was not a requirement, did you somehow learn through the grapevine who was challenging it?
In my personal capacity, I have not seen any candidate challenges as it relates to city individuals qualifying for office.
Yeah, we haven't seen any challenge either.
I don't think that's in dispute.
And can somebody running for office have two addresses?
There, to my knowledge, there are no provisions in election code that prohibit an individual from having multiple addresses. We have had hearings where individuals have had multiple addresses, and in those times, the Board of Elections followed OCJ 21-2-217, which sets the residency requirements as to which determining residency for an individual, we followed that particular code section and the 15 points that it outlines for determining residency and made a determination. So I am familiar with individuals having multiple residents.
I'm sorry to put you on the spot like this, but do you remember what some of those requirements are that they'll use to determine which residency?
I believe, and I'm paraphrasing here, that code section has relevant mail such as a lease, a utility bill, driver's license, homestead exemption. It has a litany of things that a candidate can submit once they are challenged to prove their residency.
And isn't there something, or don't they try and look at the intent of the candidate as well?
Intent is a subsection of that particular code section. What is the intent of an individual to determine their own residency? Residency is not something that is easily gained or lost, even with vacating a premise with the intention of returning to that premise according to that particular code section. We've had actual hearings and court cases in determining that, so.
What was that code section again?
21-2-217 is the residency requirement
Thank you.
under OCGA.
Thank you.
In your opinion, does Mr. Caldwell qualify to sit for, to be a candidate on the ballot?
I am a representative of Douglas County, and thus I'm not legally eligible to present an opinion piece. What I've stated here is simply the accurate information as it relates to voter registration.
And not in your official capacity, from what you've seen, just your personal opinion, does it look like he's qualified to sit?
I would object to this, yes. This line of questioning is inappropriate for this witness.
Well, the legal stuff is what the superintendent and I will work through. We understand the issues. Okay. Thank you for your time.
Once again, my name is Miranda Jordan. I just have a few statements on behalf of the city. I want to make it clear that the issue in this matter is not whether Mr. Caldwell is a city resident. It has been established that he is a city resident whether he lives at Bowden Street or at Crystal Creek Place. The reason that there was a question regarding his ability to qualify as a candidate in the Ward 3 Post 1 election was because he was not able to establish through the documentation he provided which address is his actual legal residence. And I want to also point out the term legal residence or domicile. It's a legal term of art, Mr. Meeker, as you know. That's one of the first things that we study in law school as far as establishing domicile. And 21-2-217 provides, section A3 provides a person shall not be considered to have gained a residence in any county or municipality of this state into which such person has come for temporary purposes only without the intention of making such county or municipality such person's permanent place of abode. Mr. Caldwell has testified that he keeps his Bowden Street address as a place where he can return should things not work out in his personal relationship as an independent individual. He has not shown that he has an intent to remain at the Crystal Creek address, and that is one of the requirements under the code that both of us have cited today for establishing domicile. Subsection A9 says the mere intention to acquire a new residence without the fact of removal shall avail nothing. Neither shall the fact of removal without the intention. I believe that also addresses the point of his previous residence alleged by him on Bowden Street is where he could potentially go back to should something happen at his residence at Crystal Creek.
I object, that's a mischaracterization of what was stated.
I'll move on. So I would just give the information based on this statute that domicile is established through the testimony of Mr. Caldwell today and through other documentation that the city was able to ascertain at the time of qualifying. This information is the affidavit of candidacy as signed by Mr. Caldwell on or about August 19th of 2025, and the affidavit of candidacy for the school board election signed in March of 2024. Mr. Caldwell testified today that he has lived at Crystal Creek for 1 year and 6 months. He also put that on his affidavit of candidacy for the City Council Ward 3 Post 1 position. If that were true, if that is true, then the affidavit of candidacy that Mr. Caldwell signed for the school board election in March of 2024 would have been inaccurate, because that would have required him to live at Crystal Creek in February of 2024. Because of those conflicting dates on official affidavits sworn under oath, that is the reason the city did not qualify Mr. Caldwell for this position. And I also want to make the distinction. There has been an allegation today that Mr. Caldwell was qualified and then disqualified. Mr. Caldwell was never qualified for the position, which is why he received his money back. If he had been disqualified, he would have been unable to receive the filing fee costs for candidacy. But he did receive that refund because he was never qualified as a candidate. And I want to make that clear. There was no special outside investigation that was done for Mr. Caldwell that was not done for another candidate whose residency was in question, Mr. Charles Lawler. I want to make it clear for the record that both candidates were properly vetted and determined to be not qualified. The election superintendent is allowed under OCGA 21-2-217, Section B, to look at factors such as financial independence, business pursuits, employment, income sources, residence for income tax purposes, age, marital status, residence of parents, spouse, and children, if any, leaseholds, sites of personal and real property owned by the applicant, motor vehicle and other personal property registration, national change of address program information sponsored by the USPS, and other such factors that the registrars may reasonably deem necessary to determine the qualification. That was done in this case. There was nothing biased. There was nothing that was improper. And any legal conclusion that any such action was done inappropriately is just that, without any evidence. Mr. Caldwell was given the opportunity to meet the due process requirements, given the opportunity to have a hearing today. All the information that we have learned that we did not already know through proper vetting and investigation was that he has 2 addresses, but only one can be a residence. Thank you. There's one additional point. The lease that was provided for the Crystal Creek Place address does not list a rental amount. And I'm curious as to how much monthly rent is paid, because if there is such rent as Mr. Caldwell testified, that would create an issue of a potentially a void contract.
if I may, for posing questions. City made a point to state that Mr. Caldwell was not subject to any special investigation. I'm curious, did they ask all of the candidates to provide leases, and did they talk to all of those landlords for all of the candidates, or just Mr. Caldwell?
Are you asking me that?
Since we're posing questions, I don't know if I'm supposed to answer the question that she posed. If so, then I would like some of my questions answered as well.
The only reason Mr. Caldwell was asked for additional information is because when I looked on the voter registration Excel spreadsheet that I received from the county, his address differed. And it was not in the district which he was running for or trying to be a candidate for.
But yes, I would like my question to be answered by Mr. Caldwell regarding the amount of rent he pays at the Crystal Creek Place address.
Mr. Caldwell, do you have an answer to that?
It's not a set amount, it's based on what the bills are. It's a fluid amount each month. If the electric bill is more, then it's more. It's from what I understand.
Okay. Mr. Caldwell, that's your testimony? Okay, thank you. Okay. Anything else we need to know?
And just to follow up on, well, I guess, on, did you, look at his voter registration in real, did you refresh it? Was it looked at in real time?
No, I went by the document that I received from the county, and I immediately called them, and they said it still showed the old address.
Okay.
So you verified the address?
Yes,
Okay.
yes.
Milton Kidd, Elections Director for Douglas County. The city clerk is correct with the information that was displayed on the spreadsheet that she received, but as I stated before, Douglas County receives records from driver services and is processing those in batches. So although an application may not be processed on that specific date, whatever the issue date that the license is issued with driver services, that becomes the voter registration date, which I believe is what happened in this particular case as well.
Makes sense. Okay. Anything else?
Are we gonna do a closing, or is that what you're asking for?
We can do a closing, I mean, whatever. I don't feel the need for it, but you guys are welcome to do whatever. I kind of viewed your opening to be kind of a closing as well. You sort of tracked it, and Ms. Jordan sort of did the same thing.
Yeah, my client would like to make a brief statement.
Sure.
So to all, I would just like to make a final statement. And I have, of course, service for many years. One of the youngest for Douglas County, one of the first for Douglas County to be elected. I was the youngest in Douglas County for nearly 10 years, right? My reason for running for public office, because I understand that change is necessary, right? And doing right by the people. Also, I have been a policymaker sitting at the Board of Education, and policy is set in place for us to follow. And so what is very clear is that we can't have it both ways. We can't have validation one way. And so as attorneys and other law-making officials, the city charter is clear. It states what it states. Anything prior to asking about my residency, et cetera, that's all fine and well, right? But none of that is pertinent to what the city charter says. And so based on the city's own admission and the charter, I meet the qualifications. We can look at prior addresses, we can look at when I qualified for Board of Education, et cetera. But none of that information is pertinent, nor does it matter to when I qualified based on the city charter. Whether we can look at what my intent is or where I stay, et cetera, my intent was proven based on the Mr. Milton Kidd. It was my intent to where I intended to live based on what my issue date for my driver's license was very clear at the time that I qualified. It was also stated that I was not qualified. I'm not a liar. I was told when I left out of that office on Wednesday that I was qualified, and then it was followed up with the other statements that if I did not qualify, then my money would be returned, and that if it was challenged, then other things would happen. That is what I was told when I left that office. So it's not that I've made up this whole process, but I think what's very clear is that I was not given due process. Even if there was a challenge that took place, the only reason we are here for a hearing is because I requested a hearing. It's been stated that there was a challenge made, which is fine, a challenge could be made, but Mr. Caldwell was not made aware that there was a challenge. Mr. Caldwell was disqualified, and even the letter said that I did not meet qualifications, which means that I'm disqualified. Ms. Jordan said that I was never qualified. So if I was never qualified, how could the city send a letter to me saying that I was disqualified and did not meet qualifications? So here it is, standing here at the city of Douglasville in this hearing, there's been conflicted information that has been given. And as law-abiding people, as policymakers, et cetera, we can't have it our way to be able to fit whatever narrative we want to push in that moment. Reality is, based on the city charter, I am qualified, and I should have remained qualified until there was a hearing set to tell me why I was disqualified. I didn't go to law school, right? But I think what's very clear from the legal people who reviewed the charter, you can't have it both ways. You can look at anything that happened prior to, but based on what I stated, I asked the city in March, what are the qualifications? The city told me, and they cited the charter. I could pull the email. The city cited the charter. So I went off the information based on the subject matter expert. So then now to be here at this hearing to say that, oh, you don't meet qualifications or it was contradictory information, none of that stuff matters, as null and void, because what the city charter says, and based on the city charter, I am qualified. The independent investigation, et cetera, on why, yes, there was another gentleman that was mentioned who she said was, Ms. Jordan mentioned was disqualified, right? But that shows two of us, where there was an independent investigation that was done versus that of the other candidates. When we pulled the open records request, what other information did anybody else have to submit? They didn't submit that. And to Mr. Kidd's point or his statement, had the information been requested in real time on where Mr. Caldwell lives, then we wouldn't be here. But it was not requested in real time. Ms. Vicky stated that she used the information that was submitted to her prior to. So it's that this is a serious matter, because here it is, I have been plastered on the newspaper, all this stuff has happened because the city did not do its due diligence. And it's that if it's based on qualifying candidates, how do you not qualify or request information in real time? If there was a question on where I lived, there was an opportunity to request that information in real time. Also, my license showed the issue date. And so if what Mr. Kidd is saying is accurate, then at the time of my issue date, that is the real time that the city should have gone by. And more importantly, there's a city charter in place that says that 12 months, and also at the time of qualifying, anything else prior to. And I'm saddened that this has come to this point, because I absolutely adore Judge Rollins. And I feel that the city has put him in a very, very bad situation based on trying to prove their point when all the city had to do was do the right thing. Go by the city charter, go by the accept my affidavit, qualify me as you have done every other candidate. But the independent investigation as to where I lived and where I served and how I qualified and what affidavit I signed prior to, none of that information is relevant to the city charter 2-11 that states, and in that charter it states, it's very clear, that I meet the qualifications for city council. More importantly, if I did not, then there was due process that was due to me, and I should have been made aware that there was a challenge. I should have been set for a hearing, and then the information should have been presented on why my residency was challenged. That did not happen. I received an email stating that I did not meet qualification, also stating that I did not qualify. And the only reason that we have a hearing is because I requested a hearing. The city did not, and the other thing that I find absolutely disheartening is that the city attorneys were copied in the communication from myself and Ms. Vicky. And no one, not even, they never contacted my attorney, but no attorney stood in to say, hey, listen, we are not operating in due process. I'm not an attorney, but I've studied this information, and the city attorneys saw the communication, or at least were included in the communication, and no one said, listen, we're not handling this process properly. That's disheartening, because they are put in place to safeguard the city, but also to make sure that things are done properly. And to know that here it is, there's a challenge based on a code section that I imagine the attorneys have reviewed, I imagine the superintendent has reviewed, and here it is, the legal experts have gone against everything that is put in place to be able to help govern this city accordingly. And now here it is that we're at a hearing that still did not allow due process. And here it is, we're still looking at information that is not germane to what the city charter says and how a candidate must be qualified. Thank you.
I have a question before you sit down. Are you saying today's hearing didn't give you due process? That we've done something wrong in this hearing today?
What I'm saying is that the reason, no, not this hearing today, but what I'm stating is that the reason we are at this point is because I
Understood
requested
but
that.
You just said something about this hearing not giving you due process. Is
Well-
what I thought, and maybe I misheard you, but before we close this down, I wanted to make sure that you guys said everything you felt like you needed to say.
I don't think that was my point.
Okay, that's
Yeah.
fine. I just want to
Okay.
make sure we were clear on that.
Okay,
Okay.
certainly.
As far as I think we're good. Anybody have any objection to me closing the hearing? Or letting Miss Vicky close the hearing, I'm sorry.
Just for the record, the legal standard that was brought up was into where I intend to live. That's not the legal standard under 21-2-217 for the definition of residence/domicile. That's intent to remain.
Okay.
Thank you.
And just very quickly, is there a challenge that, because I believe under the statute, we're supposed to get a copy of it if somebody challenged it?
I think, and I was just looking over at the notice, there's a legal distinction in my mind between saying a candidate did meet the qualifications versus somebody actually challenging it. I think whoever runs elections, I know this for governmental entities that I represent, that they have to make that initial determination. And that's the way I read the letter. I don't view that somebody filed a challenge to it. I view that in doing the due diligence, that the election superintendent reviewed things. I also heard her testify, and I think there was consistency that she double-checked the addresses with the county in terms of what address they had. And I think that was actually done on the date, if I'm understanding it right, it was done on the date that the candidacy affidavit was submitted.
Okay.
So that's where the information, I also believe the testimony was that those addresses update sometimes in real time, but I think he testified as to batches that come in, so.
For the record, the legal distinction as to that address date that is on the county for voter registration. With municipal elections, there is no voter registration deadline prior to an election. For county and other elections, there is a registration deadline that you have to be registered for before qualifying. So this one, you're still processing voter registration applications even up until the day of qualifying and after qualifying. And once again, as per Georgia law, any registration that we receive from driver services, the registration date will be the date that is issued with driver services.
Okay. And we have Exhibit 2, does the court, I have not gotten a copy of Exhibit 2, which was the lease and information. I know we admitted it, so I just want to make sure we get a copy of it both for myself and for the court reporter. Do you have anything further? Or are you good? Okay. Thank you. Okay. Unless there's anything else, then I think you can go ahead and close the hearing.
Yes, if there's this meeting is adjourned, since there's nothing else to say.
For the record, I anticipate having something issued probably later this afternoon. I know the time is of the essence with all this.
Thank you.
Thank you.
Time's 11:45.